When couples go through divorce, the last thing they want is to go back and litigate. However, there are reasons when people have a legitimate reason to set aside a legal separation judgment or divorce judgment. Reason number one is mistake, surprise, or excusable neglect. We're looking at the code section CCP 473. Couple examples: if one spouse did a default judgment against the other spouse and served the other spouse by publication. Let's say the other spouse was nowhere to be found. The first spouse did it by publication, and then suddenly the spouse who hasn't been served but served by publication reappears within the 6 months of that period and said, stop, we didn't litigate, asset split, spousal support, excusable neglect, I was traveling, or surprise, I didn't know, and then mistake if they reached an agreement and made an honest mistake. So that can be also corrected. Then there is the second reason to set aside, which has longer statute of limitation. Statute of limitation means if you wait more than that period of time, you waive your right to set aside the judgment or legal separation judgment. Fraud would be 1 year after discovery. So, for example, you find out that your spouse defrauded you by saying, oh, his business is worth 1 million, and you didn't know any better to do more discovery, and you didn't have an attorney, but you relied on that representation, or the spouse didn't disclose an asset completely. That could be a reason for setting aside, omitted it. So that could be also considered perjury, which is 1 year after discovery as well. If you received preliminary declaration of disclosures, which is income and expense declaration, assets and debt declaration, and one asset was not disclosed and you found out later accidentally, then from the moment you found out, you have 1 year to set aside a judgment. Mental incapacity. At the time when you signed an agreement, you were not in a sound mind. This is a little bit tricky because you will have the burden of proof to show that you were the one who didn't have the mental capacity to understand the legal consequences of the agreement that you were signing. And then you get 2 years to set aside the judgment. And finally, the longest statute of limitation is 3 years for breach of fiduciary duty. This is codified in Family Code section 1101, and it relates to community property. If a spouse did something to the community property to the point where the other spouse's interest has been infringed, breached, that a spouse got less money because of the action of the first spouse, then the injured spouse can ask for, within 3 years of actual knowledge of the breach, to set aside the judgment. Whew. Long video, not easy to do. In my 13 years of experience, I have seen only once someone successfully going through the motion of setting aside. Usually it's really, really not that easy because a judgment is a judgment. Whoever is filing a motion for the sake of filing a motion it can fire back for filing a frivolous motion because the person who files it has the burden of proof to show all the reasons for why the judgment should be set aside. So it doesn't happen very often, but now you know at least the statute of limitations. I hope that was helpful. Click like, subscribe, and I'll see you in my next consultation. Bye!